My name is Frank Avila. I'm the attorney for Patricia Horton and Elizabeth Arias Ibarra, who are candidates for clerk in the city of Chicago, and they've both been objected to by an objector who is not registered to vote at the address listed on his objection. To my left, I also have Zara Quadri, who is a candidate for alderman in the 50th Ward. She had two false objections placed against her by Mark Tenenbaum and Sheikh. Of course, they're political masters behind these puppet objectors. I'd first like Zara Quadri to speak because she has to leave, and then I will continue.
Hello, my name is Zahra Qadri. Like Frank mentioned, that I got two challenges, and thank God that I'm on the ballot. And I'm requesting everyone to please fight against crime and work hard with us to make our dreams come true. Thank you very much.
Thank you. Thank you very much, Zara Quadri, 50th Ward Alderman candidate, one of my clients in last two cycles. Every time she's been on the ballot, but because of her hard work and my lawyering. Now, I have these two young women. One of them is here, one of them left earlier, but I think you've already interviewed. Elizabeth Betty Arias Ibarra, or Ibarra Arias, and Patricia Horton, who I've known for a very, very long time. She was a commissioner of the Water Reclamation District, and she served with my father, Commissioner Avila, who's still there, and Commissioner Avila, my father, and Commissioner Horton were extremely good commissioners on the WRD, giving money back to the taxpayers, keeping a AAA bond rating, and doing a number of great things for the environment. But unfortunately, I'm here today to report a horrible incident where Elena Valencia, who's the appointed clerk, not the elected clerk, the appointed clerk, and her political masters, Rahm 16 shots Emanuel, and Speaker 3,000 affidavits against Krupa Madigan, and their political pit bull, the master attorney, Michael Casper, have submitted a false and perjurious objection of an objector who does not live at the address listed on his petition. Moreover, not only does he not live at the address listed on his petition, he's certainly not registered to vote and was not registered to vote at the time that he filled out his objection. How do we know this? Well, first of all, we looked at his name on the objection, David Daniel Gerhardt Rogers, and we found out that that name doesn't even exist, not at the City of Chicago Board of Election Commissioners, not at the Illinois State Board of Elections, not at David Orr, or now Karen Yarborough, the county clerk, the electoral authority of the county, and the name didn't exist anywhere. But then we started digging deeper. It wasn't registered to vote at the 53rd Street address that's listed on the objection. But we started then going reverse, looking previously at voters that were there previously, and then we took out Gerhardt. We found a name that we figured may be this person by deduction and probability, but we shouldn't have to do that. This process should not be, where is Waldo? This process should not be, we find the map like Dora and go on a treasure hunt. The process should be clear, it should be following the law, and it should be easy. But we found that he registered the vote at 6448 South Ingleside and not on the petition. Not only that, before he was at the 6448 South Ingleside, he was at the 6330 South Ingleside address. So he said, I didn't intend to move there or live there or vote there, even though he said he lived there every single day, sleeps there every single day, and as a live-in boyfriend. So if you're live-in, that means you're living. Live, living. Live, living. Yet the hearing officer said, oh, well, we found that credible. That's crazy. Either the hearing officers are in cahoots, they're negligent, they're stupid, or they're corrupt, or maybe all four or a combination of some of the above. But whatever it is, we cannot allow this to pass. This is fraudulent. It is criminal. It is wrong. It violates ballot access. It's racist and it's sexist. Because the hearing officers are white, both of them. The lawyer is white. And the masters, Emmanuel, 16 shots, Rahm, and Michael Casper, the pit bull for the speaker in Madigan, with 3,000 affidavits against Krupa, are white. Now, they have their minority puppets that they like to use. Why? I'll tell you why. Why are they challenging these young ladies? They're challenging them because the parking meter tickets and the red light tickets and the speed camera tickets are causing low-income people to go into bankruptcy of all races, colors, and creeds, and genders and religions and everything else, but especially African Americans to go in bankruptcy because it's a form of gentrification and oppression of the poor. And both Ibarra and Pat Horton, who are running against each other, but they're both supporting each other in ballot access. Initially, Ibarra, through her people, had filed an objection against Horton. They got together and they said, why are we fighting? And that objection was dropped in the spirit of sisterhood, in the spirit of a black and brown coalition. So the reason they're doing that is they're making a lot of money, though, the private companies who have these contracts and for the city for revenue, and it's a way to oppress the poor and push out poor African Americans out of the system, ethnic cleansing, forced gentrification, and the bankruptcies that are hurting people, and we want that to stop. And we support Alderman, both Ibarra Arias and Pat Horton support Alderman Carlo Rosa's proposal to extend the period of time to pay, to not have it double, and to be on payment plans. Moreover, we also are going a step further to want to extend the time of the yellow lights, and even to eliminate most, if not all, the red light and speed camera tickets altogether. And if there's an area that's a concern, that's truly a traffic issue and not a revenue issue, truly a safety issue, then we can look at that. But the red light cameras have even increased rear-end collisions, increased accidents, less safe, all about revenue, all about hurting middle class and working poor and poor people, and bankrupting them and making them choose between paying their tickets and their food or their mortgages or their rent. Forcing people out of their homes, forcing people out of the city, bringing bankruptcies affecting their jobs and their livelihoods and their credit. And that helps the rich and these companies and the politically connected, but hurts everyone else. And that's the reason Madigan and Rahm Emanuel, 16 shots Rahm, and Madigan, 3,000 affidavits Madigan, and their pit bull attorney are trying to stop these two women of color. And I call on Anna Valencia and her puppet masters, Madigan and Rahm, to drop this fraudulent objection now. We filed an objection to strike and dismiss. The objector does not live at the address stated at the petition, and he's not registered to vote at the address. We cited 3 appellate court cases, the Daly case. On the first case, on the Horton case, he said he saw a box. We don't know, it was an open box, a closed box, a gift box, a Christmas box, a New Year's box, a Hanukkah box, Kwanzaa box, Jack in the Box, trick box. I don't know what it was. But seeing a box is not knowledge of a verified petition, of knowing what's in the petition. On the other case, he didn't even know what the objection was. He didn't know nothing. Not 1, not 2, not 3, 0, zilch, zip, nothing. That means he swore under oath to something he has no knowledge of. That is perjury, that's a lie. He also perjured himself then on 2 documents. His change of address card, he has a master's degree from the University of Chicago, but he said he didn't understand a very simple form in basic English, which is his first language. He speaks it, and he has an MBA from the University of Chicago. Oh, but I didn't know I was changing my address. Well, it changed right there. Change address to, from. And he said he went on election day to his girlfriend's precinct. He was in a rush, and that's why he changed his address. That's a lie. We got the documents. He voted the day before Election Day, November 5th, at the 20th Ward early voting location, and they do not require you to change your address at early voting. Then when he gave his testimony, he said he's the live-in boyfriend. But the hearing officer said, oh, we find him credible. He lives at 53rd Street. Well, how can you be the live-in boyfriend if you live somewhere else? Living. And he said he stays every single night at 6448 South Ingleside, and he eats there and he contributes there. He said, well, I got some clothes and memorabilia. Well, I got some wrestling in grade school and baseball and soccer. Now, this is a long time ago. I got these trophies. They're still at my mama's house. She didn't throw them away. That don't mean I live with my mom. I live with my wife. Now, he also, I got some clothes. Well, your baby clothes don't count, okay? He gets up in the morning, he showers, puts on clothes. They're at the house he lives in. He's with his girlfriend. He lives there. He admits he's a living girlfriend. He admits he eats there and stays there every single day. His intent is irrelevant. Also, the Neely case clearly state the intent of where your residence is your voter registration. He not only registered to vote once outside the 51st Street house, but twice. Once at 6330 South Ingleside, which was the apartment of his girlfriend that she rented, and then when she bought a home, then she registered to vote at 6448 South Ingleside. So twice he registered to vote away from the 53rd Street address. You could maybe make a mistake once, I doubt it. His testimony was BS, the form was clear, but not twice. This is a clear violation of the laws of the election. This is a clear violation of democracy. If these 2 young women, minority young women, an African-American young woman, an Hispanic young woman, the Hispanic young woman's a single mother, vice president of the bank, Pat Hornwell, she looks too young to have it. She has 5 children and grandchildren. Was a commissioner at the Water Reclamation District and did many wonderful things there. Like I said, in the last time, she had a AAA bond rating, lowered taxes, and protected the environment. Just a wonderful job with my father, Commissioner Avila. They will knock the only African-American female off the ballot running for this office. Thus, the incumbent appointed clerk will win by default with no choice, with no competition, and no democracy. There's so many layers of this that are offensive and disgusting. Now, the broader picture is, on this particular thing, is we have rights for the objector, which are up here. The rights for the signer and the candidate are down here. I cite 3 appellate court cases which have been not denied. There's been no cases that are contrary except some cases cited about the candidate when the candidate's name is not in question. With that, I'd like to turn it over to Pat Horton, and she can talk further about this atrocity that's happening.
Thank you, Frank. And I'm standing here before you today because as of today, I am working upstairs in the records exam. In a records exam that should not be carried out at this particular time because the objector does not qualify. He committed fraud. He committed perjury. So I should not be in the records exam. So I urge you, if you hear me, call. Tell everybody. Let them know what's going on here because this is not fair. And as your city clerk, I promise you, I will create an office that fosters transparency and trust. And I will have an office that will engage all of you in all 77 communities. But more importantly, because of all the distraught and the hurt that has been brought upon this city of Chicago, what I will do is I will call for a moratorium for 1 year to make sure that we add some relief to these individuals and families who have been hurt by these massive, massive bankruptcies. I'm Patricia Horton, and I am running for city clerk. God bless you.
One thing I also want to state is that in the law in Pucci, which is an appellate court case, it's quite clear that even though the factual aspects were distinguished, that the objector in that case did not list an address, the objector must state the address which he's registered to vote at. And in the case of Daley, it's held that you must have some knowledge of the objection to make it in good faith. There's a good faith standing. Both are appellate court cases, and Daley is from this first district. You also have the case of Neely, where Neely says where you register to vote is the biggest factor, especially vis-a-vis elections, of where you are, where you reside. So those are 3 cases that have gone undenied. And then you have the factual facts that he's registered away from the address listed on the objection petition twice. But the bigger picture is that you have a very high signature requirement for an obscure office like clerk in this day and age. That's very high to get, especially without patronage and other things that in some places no longer exist, except for very rare incumbents. You have very high onerous hurdle and an objection process for validity of signatures that really requires 3 times that amount. So really you need like 30,000 signatures, or at least, you know, or more to get on the ballot. And that is not right. 37,000 signatures would be, you know, to get on the ballot or more, really 40,000, at least 25,000 signatures just to be competitive, plus an objection process that is very onerous. Whereas these objectors seem to have no responsibilities or burdens at all, and this is false. I really hope that Anna Valencia, through her puppet masters, Rom 16 Shots Emmanuel, and Speaker 3, and a cover-up, and Speaker 3,000 false affidavits against Krupa Madigan, get their pit bull to drop this objection, and this should be referred to the Cook County State's Attorney and to the FBI. Thank you very much.